Welcome, everybody. We're glad you're tuning in again. We've got Matt Zorn with us, a litigator at Yetter Coleman out of Houston, Texas, and he has become the leading litigator in the United States on federal Controlled Substances Act issues, including cannabis and psychedelics and right to try and research. And we're going to dig into a little bit of that today. So thanks for being here with us, Matt.
Thank you, Lisa, for inviting me. It's wonderful to be here and to have this chat with you.
Thanks. So could you detail a little bit about your federal procedure and jurisdiction experience that kind of allowed you to be able to dig into this cryptic DEA work?
Sure. Well, I started my career as a commercial litigator at a fantastic firm in New York called Paul Weiss. It's a big law firm, and I learned from um, some of the top sort of litigators in the world there. And then I kind of transitioned from commercial litigation to patent litigation, which is always in federal court. So kind of learn the federal rules. That those are the guidelines that you follow as a patent litigator. You're always in federal court. You don't really do any state court matters. And then I went to go clerk and worked in Marshall, Texas. And I did mostly, again, patent litigation, which on its face doesn't seem to have too much in common with what I'm doing now with cannabis and psychedelics, but actually, a lot of the skills that you need to get good at patent litigation, construction, like how do you like interpret what a patent claim means, is very similar to what you do in the cannabis and psychedelics space, at least what I'm doing in the cannabis and psychedelic space, which is a lot of regulatory issues involving regulations. It's about understanding and construing regulations based on the text. So I found that the skill sets were very comparable in terms of sort of on an abstract level. But the final thing is not to toot my own horn, but I learned quickly. And so I learned a lot of the things I need to do on the job as far as the case law that's relevant here. And so those are the skills. I think the other thing I would need to note, though, as part of the answer for it to be complete is in law school, I was very interested in drug policy and the Controlled Substances Act. So when we talk about the history, and I do a fair bit of the history and a lot of what I am writing, but even if it doesn't end up in the brief, it's really important to understand kind of how you got there. And I don't think a lot of people do understand the history of the Controlled Substances Act, whether it's cannabis or the other substances. I even read something very recently in the New York Times there. I thought there were some mistakes about describing kind of how the Controlled Substances Act came to be. So I got an undergrad degree in history, and I just kind of I've always kind of enjoyed the history of things and the Controlled Substances Act and federal regulation of drugs in particular. So I just have a kind of a deep reservoir of experience there for no other reason other than personal interest. Well, not tied to any case I've ever done, just something I've read about and sort of put in my mind's repository of knowledge.
Well, and you do learn quickly. While a lot of attorneys kind of dip their toe in the water and see how warm it is for a year or two in the cannabis industry, you jumped right in. You made the biggest splash that could possibly be made in your lawsuit on behalf of Sue Sisley pertaining to research. Can you talk a little bit about that and how you got your traditional big law firm to go for that?
Yeah,
Pro bono marijuana case.
yeah, and I think so. I do need to say I don't work at a big firm. I work at a small boutique in Houston, but I think your characterization is correct in the sense that we work on high stakes litigation across the aisle across the V from big firms all the time. And in the case you're mentioning, it's across from the biggest law firm of all, which is the United States government. And the way I got into that was it's a long story. There are kind of personal details, like many people who are in the cannabis industry. I the medical issues kind of struck close to home. Um, but I didn't really get involved as a lawyer until I saw Dr. Sisley present at South by Southwest in 2019. And um, the thing about her story that struck me kind of really deeply was, for years, even today, the federal government has this mantra of, we want more research. We need more research. We're not going to do anything with cannabis, marijuana, until we see research proving its safety and efficacy. And here comes along a person named Dr. Sue Sisley, who had been spending, at that point, it was like a decade, it was 2019, trying to do a safety and efficacy trial with cannabis, and encountering every piece of bureaucratic red tape and from both the government and the institution she worked at. And as far as I could tell, she was doing everything right. And it was, it was kind of the fact that she had submitted an application to grow cannabis for her own research, because the cannabis that you could use at that point in time was only at the University of Mississippi. That is not true today, despite some, again, inaccuracies that are reported. You can study other cannabis now, including from Dr. Sisley, and there are a couple other folks who are willing to supply cannabis research. But at that time, it was only the University of Mississippi. And so she wanted to grow different cannabis because she didn't believe that to be representative of the cannabis people use. It's not. And the government, they wouldn't even have the courage of giving her a decision, yes or no, because if they had said no, she could have appealed the decision, but basically, by not giving her a decision, she was unable to appeal anything, and it was like her application was held in limbo. And I was sitting in the audience at the time. I'm sure she didn't. I think there were other lawyers, but you know, I also had, I mean, this is kind of where I started or ended my last answer of, I had this deep repository of like the Controlled Substances Act and kind of the knowledge of it. It wasn't as deep then as it is now, but at that point, I wasn't coming into that with like cold and listening to this. And I also knew just enough about administrative law to know that what they were doing, this was a conscious effort to avoid judicial scrutiny. And I was just
Absolutely. I
offended.
just want to interrupt you real quick to go
Yeah,
back for the listeners. The senators and governors are petitioning the DEA all the time to ask them to reschedule marijuana. And every 5 years or so, they respond and they say, nope, no medical use, still Schedule 1. But
yeah.
in August 2016, they reiterated still Schedule 1, but they said, but now we will take research and they, applications, but they
Yeah.
never took action on any of those. 5 years later is when you are meeting Dr. Sisley.
No, it was 3 years. It was 3 years later, but she had submitted her application shortly after. And you're, I mean, that's exactly the problem, what you identified. And thank you for adding those details. Because I need to put this kind of in context, which is, when I was saying that the mantra that people are hearing of like, we need more research. I mean, this wasn't just like people like getting behind a podium and saying that. They said this in the Federal Register to deny rescheduling. They said, well, the research isn't there. And then, like I said, you turn around and you meet a person who's willing to do the very research. They're not talking about look, the fact of the matter is, I don't want to say it's a lie, but to say there's no research on cannabis is, you can go on PubMed and type in marijuana cannabis research. You'll get thousands and thousands of papers. There's plenty of research. Nobody who's telling you there's no research is telling the truth. What they really mean is there's no FDA double-blind placebo clinical research that's progressed to phase 3. And that's true. But again, what got me really irritated about Dr. Sisley's situation was, here was someone willing to do that. Like, this really, like, I don't agree that that's the only type of research that we should look at to determine accepted medical use under the Controlled Substances Act. Even assuming that we're correct, the fact that the government was preventing her from doing that research was offensive, right? And really deeply offensive. So I approached her afterward, and she probably thought nothing of it. And I said, look, I'm going to look into taking your case pro bono. And I didn't quite know enough about administrative law at that point to really get in on it. And that's where I came back to Houston and talked to Shane Pennington, who at the time worked 2 offices down from me, but we didn't, he was an appellate lawyer and worked on appeals, and I was a trial lawyer working on trials, and we didn't really cross paths. Um, but he's also an administrative law guru, and I presented him the problem, and we kind of hashed it out and filed our first lawsuit together on behalf of Dr. Sisley. And how do we sell that to the firm? I think that was the second part of your
Yes.
question. I think it was it's just everything I kind of described to you of, you know, and I'm not sort of suggesting that the cannabis industry is doing anything wrong now by breaking the law. I'm just trying to emphasize Dr. Sisley was not breaking the law. She was trying to follow the rule book to the letter, and she was still tripping up. And so um it's a lot easier to sell that. So like a lot, plus it was research. This is not a controversial thing, right? Like I wasn't even promoting like medical marijuana for cancer patients at that point. This was just about research, and just being, the firm knew I had a somewhat personal connection to it, and there was no hesitation. I got no pushback. Like there was not. Nobody asked me to justify myself, but I did give them a 4 to 5 page memo, like explaining it, like, and that's something I try to do in my work product too, with my clients and my colleagues and my co-counsels. And I think it's really important to write out the reasons and the argument and show, you know, this needs to be done. That was my first brief in the case. And I won it. But then I got to write the actual brief in the DC circuit.
Well, we're glad that they supported you in this endeavor because you've gone on to continue to do a lot of good. And I was very honored to be asked to file an amicus in that case on behalf of scientists, really, kind of focusing on the opioid epidemic.
And let me add, it's a stellar amicus brief, and it was cited by a congressional committee, and not, I don't think it was that particular case, but it was a follow-on case. It's a stellar brief. It's an important brief,
Thank you.
it's been cited. So, I hope, I sometimes people ask me, hey, I've got a couple cases now, and where we could use amicus participation, including one I think we're going to discuss at the end. And people, I point to your brief and I say, look, like, you're not just writing a brief, you're writing a white paper that Congress might use. And so thank you for that. It helped me at the time, and it's helping me now still.
Excellent. Well, one of the things that I enjoyed about that, you know how sometimes you'll have a little bet with your buddies, like, I'm going to work this word into my deposition, just watch. Well, I wanted to work in a picture of juicy bud compared to the homeless stuff, and
Yeah,
got it in there.
it was a good
Well,
brief.
and so
Good
the
brief.
culmination of your litigation resulted in Dr. Sicily finally being awarded a license to grow cannabis. And you had a lot of other follow-up litigation too that resulted in the release of a secret DEA memo. Can you explain that?
Yeah, this was the second lawsuit we filed. So the first lawsuit we filed, we didn't take the distance because the government just kind of folded, and they processed her application, and the application of a bunch of other applicants, some of whom have been awarded licenses as well. So, as recently as a couple months ago, I think people are still laboring under the misimpression that Mississippi is the only place growing cannabis, and that's not true. There are a handful of places that are growing federally legal cannabis that I think are looking to have their cannabis researched. So that was that the applications were processed, that got moving. But in the sort of interim, or after they were processed, but before any of the decisions had been made, the DEA proposed new rules for the program. It wasn't clear where those rules came from. Um, except that, and I think this was kind of Shane and I just kind of applying our sort of secret sauce abilities that I can't really explain or teach. But we kind of looked at the tableau and you're like, that this didn't come out of nowhere. And, we kind of understand the workings of government a little bit, and the Office of Legal Counsel, which is, for those who don't know, is the kind of like the general counsel of the Department of Justice. They are an immensely powerful agency in the government that effectively sets the executive branch's own interpretations of statutes. And we had concluded, and it was a little bit of a guess, but it was a very kind of deductive guess, that that department, that agency with, or not, they're not really an agency, but that office within the Department of Justice had written a memo which basically told DEA that they had to enact this policy. But that memo, like many, if not most, Office of Legal Counsel memos, was not published, and it was secret. And this issue, this broader issue of OLC, Office of Legal Counsel memos being secret, is a very big issue. It's not a cannabis issue. It's kind of like a good government issue. I think there was an issue with an OLC memo with the Ukraine incident with President Trump. These memos are often secret, and they dictate weighty policy concerns. And there are cases of organizations trying to get these memos disclosed through the Freedom of Information Act. And to my knowledge, they are almost always unsuccessful. I can't even think of one that ultimately succeeded, except our case, where we exploited a circuit split between the Ninth Circuit and the DC Circuit. It's a really arcane sort of issue, but I want to make a point with it, which is the arcane issue is kind of whether or not FOIA provides whether the affirmative disclosure provisions of the Freedom of Information Act. So most people think of FOIA, you submit a FOIA request, you get something back, but there's right before that part of the statute, there are certain information that the agency is required to make public. And in the Ninth Circuit, you have a cause of action if they don't disclose that information. In the DC Circuit, you do not have a cause of action. And lo and behold, Dr. Sue Sisley was sitting in the Ninth Circuit. So we filed a case in the District of Arizona, and we said that the memo that the OLC had withheld, when it came out with this rule, was required to be disclosed under the affirmative disclosure provision because it was a statement of policy and fell within one of the buckets. And basically we kind of argued around the what's called the deliberative process privilege, saying, okay, well, and I think people will be familiar with the attorney-client privilege, which is you can't use it as a sword and shield. You can't rely on attorney-client advice on the one hand and then turn around and say, I'm not going to disclose it. And we basically sort of argued the equivalent of that. And we did it in a complaint. We did it very much a speaking complaint that laid out the law and said, hey, here we are. We got this case. We got that case. So it was kind of like a complaint/brief. It was interesting because we filed it and we were going to file for a preliminary injunction, another unusual kind of thing, except our argument was, well, the clock is ticking on this rule and you want us to comment on it, and we don't even understand where this rule came from. And I talked to the government lawyer, and he was like, well, this is a FOIA case. You don't get discovery. This is all weird. And then he was like, well, I'll take it back and think about it. And then I think like a few days later, he's like, hey, do you want to settle it? So it was, we didn't actually end up litigating that case. I filed a complaint less than 3 weeks later. We ended up settling it with the government agreeing to disclose the memo. I can only think that the reason why was not just because there was a secret memo and this rule out there, which, if that memo had been kept secret, could have potentially invalidated the rule, but kind of these other legal issues that we were kind of sort of sticking a pin in and applying some pressure on. And it just wasn't worth it to litigate it. And I don't blame them, but That's ultimately, and yes, there was a memo. There was an 18-page memo. It's on the
What's it
Department of
say?
Justice. It interprets the United States, the Single Convention of 1961, which was, I believe, ratified in 1967 by the U.S. Although don't hold me to that. It says that by virtue of the statute, which requires us to comply with international treaties, the United States has to do X, Y, Z, A, B, C. We don't do any of that stuff, and we can't approve anyone to do research with cannabis, to grow cannabis for their own research. Actually, is more accurately stated, until we do X, Y, Z, and A, B, and C. And on top of that, I think that's what was important to Shane and myself. But I think what made the headlines was there was part of that which said, for the past 50 years, we haven't been complying with this treaty, and the U.S. government hasn't been complying with the law. So um, that that's what the memo said. And again, it's on the Department of Justice's website now. Although I think if you just Google around for it, I forget what the formal title. I think it's like memo on compliance with the single convention or something like that. But yeah.
Well, great job extracting that from them. So on to some more complicated federal Controlled Substances Act policy. Um, we heard in the news that President Biden pardoned federal possession prisoners, but more importantly was his request that the scheduling of marijuana be reconsidered. Could you kind of delve into that a little bit?
Sure. I don't. The first thing I want to do is I don't want to minimize the importance of the president pardoning, and now it looks like they're engaging in sort of expungements of federal possession. The truth is there aren't many people in prison, federal prison for possession. There never have been. It's never been a government priority. But the message it sends, and that and already we see some states taking some similar actions. And so I don't want to minimize the importance of that. I think it showed pretty damn good leadership. And I think honestly, the thing for me that mattered most about that, and I think people should really kind of think about carefully, is a lot of people make a lot of campaign promises about cannabis. A lot of senators and House members are making a lot of promises about cannabis. I mean, this was the president actually delivering on what he said. This president has never promised to do anything lofty with cannabis, right? Like, he's not breaking his promise by not passing safe banking. He hasn't promised to do anything like that. He did promise to do this though on his campaign, and he made good on a promise. And I think people should really, take that. That's a big thing, especially with cannabis, because there's a lot of people who I don't know if they're not breaking a promise, they're just not they're not delivering. This president did deliver. So, but to your question about the and so I again I think I don't agree with the president on some of his policy, but I really respect what he did with respect to pardoning, even if it doesn't necessarily do what needs to be done 100%. But on the rescheduling, so the Controlled Substance Act allows anyone to petition to reschedule. Obviously, a request from the president is a lot more weighty than a request coming from Matthew Zorn. But this is the initial process of looking at the scheduling status of cannabis, and whether it deserves to be a Schedule I drug. Gathering the evidence. There's a process under the Controlled Substances Act where you gather the evidence, you look at the different factors, and the agency makes a determination as to whether or not it meets the criteria for a Schedule I drug. I want to be, to whomever's listening to this, especially if it's the cannabis industry, I want to be crystal clear about something, which is, unless the way that DEA or FDA applies the law changes, cannabis will not be rescheduled. no currently accepted medical use effectively means FDA approval. There's a slight difference. And the way that DEA has applied the Controlled Substances Act is to make that essentially a threshold requirement to rescheduling. I don't agree with any of this. I think it is a misinterpretation of the law that perhaps borders on deliberate. Because in the case you were talking about that you were, assisting Dr. Sisley with as an amicus, what we were arguing in that case was whether or not no currently accepted medical use meant FDA approval. My belief is we clobbered them on the merits. The court just never reached them because of jurisdictional issues. I don't, had the court reached the merits, we saw at least one judge write a concurrence saying, hey, I don't think that I think that the petitioners might have a point here on no currently accepted medical use. And so, the DEA and honestly, the Department of Justice is on notice that this is wrong, in my view, that the way they interpret the statute is wrong. But I just want to be clear. Yes, the president called for rescheduling. I think it's important. At the very least, we're going to get an updated scientific update. But unless people are active in trying to get this changed, the outcome is predetermined here, because there's nobody's done any clinical trials. Nobody's gotten FDA approval. So this is, I don't want to say it's a futile exercise. There's a lot about it that is that's useful beyond sort of the ultimate outcome, right? But I wouldn't get my hopes up if people aren't going to. So an example, the simplest example would be in the event that the DEA doesn't reschedule, someone should take an appeal. What's interesting about what you mentioned with the 2016 denial was who filed that petition. It was the state of Rhode Island and the state of Washington, and they filed a petition in, was it 2011, and it took 5 years, as you mentioned, to progress through. And then this denial comes out and they never appealed it. They just didn't appeal it. And I guess I just don't necessarily often, I don't get the mindset of both the cannabis industry and even starting to be the psychedelics industry of, why people aren't a little bit more active on these legal issues if they
Well,
want change.
yeah.
But let me just quickly finish this up, and then I want to hear your reaction to that. Which is, certainly pharma is active, like all these other industries tend to, on key sort of existential type issues. I'm a little bit at a loss, but it sounds like you might be able to tell me where I'm missing this.
I mean, I don't really have anything good to say about this really, but one thing that I've observed, because I came up through the ranks in a very traditional way and, lawyer for 20 years before I got into the um cannabis stuff. And, I've litigated just about every different issue. And but I feel like a lot of the attorneys that are in the cannabis space, some of them are either younger or maybe they were criminal attorneys and then they just kind of turned around the baseball cap and said, okay, now I'm a cannabis attorney. And so I feel like a lot of them don't have the same pedigree and experience in a way that someone who has slogged away as a traditional lawyer for a really long time has those skills to apply. And that's one reason why I think your background is so pertinent because it takes somebody like you with your motivation, with your skills, and with your experience to really take the bull by the horns on these issues. And so I think that's part of why I wanted to ask you to kind of go
Yeah.
over what would need to happen for cannabis to be rescheduled with this latest action.
Um, yeah, and I think you give me a little too much credit there. Although I do, like I said, I think I do have a good I have a good skill set. I think I'm very kind of fortunate in the environment in which I work that they're able to support this work. And honestly, I got lucky meeting Dr. Sisley and so on and so forth. But what needs to happen? Well, to be rescheduled or descheduled, I know it's a word, um, they're the the simplest and most straightforward way, the simplest in terms of like explaining is Congress passes a law. Um, that's not the simplest in terms of execution because it's very hard to get anything done in Congress, but that is the simplest, most straightforward way. But let me then sort of emphasize the point of it is categorically untrue that that is the only way. And I still see people saying things like, well, DEA can't change this, the attorney general can't change it, the president can't change it. That is not true. Um, 21 USC 811A is the petition process and the rescheduling process, and it gives the attorney general and by extension DEA, and again by extension the president. Remember, all cabinet officials serve at the pleasure of the president, and it's true the president can't order the rescheduling via executive order, but he can fire someone if that person is not carrying out his agenda, and that happens. I doubt it's going to happen with cannabis because cannabis has not quite yet climbed the list of like what I would call like you know ride or die type issues. But there's you know the boss is responsible to some extent for what his subordinates do. So there's a provision in the Controlled Substances Act that allows the attorney general to reschedule substances based on particular findings are made. I think in my last answer, I kind of said one of those is the currently accepted medical use prong. There are two others. There's high potential for abuse and lack of accepted safety for use. Well, what needs to happen for rescheduling to occur is the DEA and DOJ are going to have to buck a little bit of past interpretations of the Controlled Substances Act, which they can do and agencies do all the time in administrative law. I mean, this is not a crazy ask to say, you know what, we're not really asking you to change like currently accepted medical use in 99.9% of cases is going to be FDA approval. But we've got this really weird situation where, 75% of the states have laws accepting it, as accepted medical use. And in that case, we're going to also find that there's accepted medical use. I mean, that's what would be required. And that's not like a crazy thing from a legal standpoint or interpretation of the text. I mean, our argument in the litigation was very simple, which was any person with command of ordinary English language would look at a map of the United States, see all the ones that had accepted medical use, and look at the language and come to the conclusion that there was some accepted medical use. That's all. What?
Does there have to be sign off from other governmental agencies like FDA or National Institute of Health, or are we just talking about the DEA,
Yeah, no,
the
strangely,
AG?
yeah, strangely, no, there doesn't have to be. I mean, and that's another kind of another misconception, which is, oh, well, it's all about the FDA. Well, no, it's all about the FDA because of the way the statute is interpreted, meaning like if you construe this to mean FDA approval or bust, then yes, of course yeah, if the FDA approves it, then, or it's really, there's a 5-part test, like I said, that it kind of equates to FDA approval. But like if you interpret the statute in a manner that requires FDA approval, it's almost a circular reasoning or a tautology to say, well, if it requires FDA approval, then we need sign off of FDA. The threshold question, though, is does it require FDA approval? And that does not, the DEA and the Attorney General interpret the Controlled Substances Act. They are the final, they are the agency that administers this and makes final scheduling determinations, and they could interpret the statute differently, and they don't need any agency to sign off on how they interpret the Controlled Substances Act. So the second pathway to rescheduling involves kind of a different interpretive issue, and one I need to flag is I'm litigating that issue now, and people may or may not be interested in it, and but it's whether or not the making this accepted medical use a threshold requirement to rescheduling, whether that's in fact correct. If you look at the CSA and you look at the schedules and you look at these different criteria, and you look at honestly the history, this is another place history comes in. it's not clear to me, or I think objectively, if you look at the statute, why accepted medical use is this threshold criteria. There are other things like high potential for abuse and lack of accepted safety for use. And you know, what happens when you meet one of the criteria but you don't meet the other two? And I think that there's a 1977 case involving Normal against the DEA, where the DC Circuit told DEA you can't make medical use the only thing that you look at. You have to balance these factors and look at it holistically. And that got kind of lost in the annals of history, and like through the passage of time. On remand, in the case got remanded, and in the early 80s, you see FDA apply the statute saying that synthetic THC could be in Schedule 2 because it had a accepted medical use with severe restrictions because it was like far enough in a developmental program. And then honestly, you see this again, this kind of this different interpretation of the CSA from FDA. As recently as 2000 with GHB, there's a Federal Register thing where GHB was far enough in the developmental program. So the bottom line point I'm trying to make is DEA has itself created these inflexible interpretations of the Controlled Substances Act that it could reverse course on. This is not, and I'm tired, but I always expect the narrative from the government of, well, our hands are tied. We can't do this because of X, Y, and Z. This is not true. They don't want to do it. They don't, and I can't tell you why they don't want to do it. I'm not sitting behind the scenes, but and a lot of times it's just as simple as they don't want to upset the status quo. But I mean, I really do want to emphasize this is a situation where the government can do it and they don't want to do it.
Yeah, I agree. And, you know, I think of DEA, I mean, and DOJ as law enforcement, kind of like in Texas, our law enforcement agency, the DPS, regulates our medical marijuana program. And it creates a very disjointed approach because, for one, they have complete disdain for this whole program. I mean, everything that they're taught and what they do is this is a drug and a crime. And nor do they make regulatory rules because they're an enforcement agency. So they're also being charged with creating a regulatory program when that's not really what they do. So I could see, that being, just a huge, just this whole philosophical um, reason, going back 50 years now. So
Yeah, I mean, it's not, and it's not. I always try to say this, and a lot of my when I get asked about this is it's not cause I think DEA is like they're bad people, or not any worse than any other federal agency. It is in some senses like at some level it's bureaucracy. It's sort of conservative, like lowercase c conservative in terms of like agencies just don't like rocking the boat, and they don't like losing control or upsetting a status quo. And
absolutely, yeah.
that's honestly human nature, right? I mean,
Hmm.
you kind of get comfortable with where you're at, and rescheduling marijuana, at least at one point in history. I mean, at this point in history, I don't, it's almost asinine to like to think that reschedule and I hear a lot of people, rescheduling will give control of the FDA or whatever. I mean, that's not, I've never understood the legal foundation of that. I mean, it's already the case that you can research a drug in Schedule 1, get FDA approval, and then that drug will be rescheduled, and now it is regulated by the FDA. So I'm not sure rescheduling results in any FDA regulate anything that's greater or less than what exists right now. But getting back to my point, I mean, it's we live in we're creatures of habit, and we don't like to see change. I think that the issue now, of course, right, is you can, a lot of states you can go down the street and like buy a joint, and why is it easier to get marijuana from a dispensary than it is to research from the federal? I mean, it just it's the height of absurdity. And then you just kind of have to wonder like why like on a practical level, like why are they doing this? Like this makes no sense. Like we're now hearing about safe banking, and it's just like I don't understand like this resistance to, yeah, yes, you're correct. Like it's true, there's this entire industry, and maybe we shouldn't do piecemeal reform like safe banking or not, and we should just do a big regulation like overhaul of cannabis and so on and so. Okay, so what's stopping you? If that's your position. It's kind of, I don't really understand where we are at now with cannabis on a practical level, and so I can only assume there are interests and prejudices and whatnot that are at play, because it's not, certainly not rational.
Definitely not. I mean, I think it's inevitable we'll get there eventually with folks like you pounding on the door, because that's what it takes. Or yeah, they're going to just keep the status quo for as long as they can. So speaking on pounding on doors, I want to shift over to the right to try. Um, so the FDA says the Right to Try Act is one way for patients who have been diagnosed with life-threatening diseases or conditions, who have tried all approved treatment options, and who are unable to participate in clinical trial to access certain investigational treatment options. Says here, FDA's role in implementing the Right to Try Act is limited to receiving and posting certain information submitted to the agency. So educate us a little bit about the right to try, what the issues are, and what you're litigating right now in that regard.
Yeah, so the right to try, it's this really kind of I'd rather almost speak of the concept as opposed to the law. The law actually has a lot of critics in Congress, outside of Congress, academics or whatever. And I think some of that criticism is merited, and some of it is kind of not. And I have personal philosophical kind of disagreements on kind of how, the size of FDA, and whether the federal government should be saying, to what extent they should be dictating it, what an individual and their doctor decide um is the right sort of course of healthcare. Set all that aside for a moment. Let's just talk about the concept of the right to try, because I think the concept is really kind of what's important to understand here. The concept behind right to try is, if you are dying or you've exhausted treatment options and you have a life-threatening condition, the requirements of safety and efficacy should not strictly apply to you. As far as the safety and efficacy of a drug must be proven before a manufacturer can introduce that into interstate marketing so that you can use it. There is a gap between kind of the FDA approval and like medicines you can use. Like there's kind of like compound pharmacies are an example of, sometimes you can get custom medicine compounded that's not FDA approved, and so on and so forth. You can have unpasteurized milk that isn't introduced into, or not unpasteurized milk, but like milk that's, the processes don't, that FDA requires. You can have that, if you're on a Texas farm, you can, have visitors to your farm and you can give them cups of milk, and you're not running afoul of anything because you're not marketing, you're not in interstate marketing. But for all practical purposes, when it comes to pharmaceutical drugs, you need FDA approval before you can take it. And there's off-label prescribing, but it has to be approved for some indication. The right to try is a challenge to this idea. It's a small challenge, but it's a very, in my view, conceptually an important one, saying, you know what, like if someone's dying, like maybe we don't have to show that this is efficacious. And in my move, it is, in my view, it is honestly, it is a more nuanced and more intelligent way to think about drug regulation. It's you're assessing the risk and reward of someone being given something that's been proven safe in phase 1 trials, but maybe hasn't been proven to be efficacious. And the reason you're allowing that is because someone is sick and dying, and they might not have the time to wait out clinical trials. So my view is, conceptually, this is a good idea, right? And that the law kind of tries to effectuate that concept. And you can love the FDA. You can think the FDA should have more regulatory power and still like the concept underlying right to try, which is just, hey, in certain circumstances, we don't need to prove a drug is safe. So that to me is the concept and the spirit of right to try, and why I think it's important. As far as the law itself is concerned, it's rarely used. Um, there is FDA expanded access. The FDA does approve most expanded access requests, 99% or more, I think. The FDA at the time right to try was passed was not necessarily responsive and maybe not approving 99%, but it's gotten better. I think that's just kind of objective data that's shown that it's gotten better, and expanded access kind of is good. It doesn't mean right to try shouldn't exist as an alternative pathway. Um I just want to point out that the law is not like this like incredibly useful thing that people use all the time. I think it's the spirit that we should be really looking at carefully and considering carefully. And that intersects with the Controlled Substances Act, right? And that's kind of where I'm getting involved.
Are there state right to try laws?
Yeah, almost all states have right to try laws. So again, the idea of right to try is is an extremely popular. I think it's something that and it's intuitive. And I know many politicians are against it. I assume anything that divests the FDA of authority in any regard, they would probably be against in some situations. But your question's a good one. It is important to point out this is an immensely popular concept.
What are the obstacles and the barriers for a patient getting to try psilocybin or MDMA or something for end of life, for example?
Well, there's a legal barrier and there's a practical barrier. So the legal barrier, and they're not unrelated. The legal barrier is, despite having a right to try act, um, and I think that these controlled substances have been shown to be safe in phase one. There are eligible patients who are dying, and or even in some one of the arguments is someone who has treatment resistant depression and is suicidal. um, that's a life-threatening condition or whatnot. So, and perhaps psilocybin or MDMA could help that person out if they're treatment resistant or whatever, and they've got a life-threatening condition. So, the main obstacle is the Controlled Substances Act. When for those drugs you mentioned, which is if something is in Schedule One, it doesn't. The right to try is an act that exempts FDA coverage. But it doesn't what we're fighting about, what we're litigating, and there's no dispute that the words Controlled Substance Act aren't in the Right to Try Act, but it's whether and to what extent the either the Controlled Substances Act requires DEA to sort of also allow these right to try uses. And DEA has said, well, we can't do it if it's in Schedule One. I don't agree with that. I don't think that's a correct interpretation of the act. But what I'm litigating most immediately is, well, we filed a petition then to reschedule psilocybin and put it into Schedule Two. Said, okay, well, this is what you want us to do. We'll do it. And we did it. And I submitted a petition, and they denied the petition, saying, well, it has no accepted medical use, so it has to be in Schedule One. So we get back to this and it has no accepted medical use because it hasn't been proven in FDA clinical trials, which is the very thing that we're trying to get around with right to try. So
Gosh, definition of absurdity.
yeah, so here we are again on the same hamster wheel, working through some circular logic. And unlike in the Sicily case, the Ninth Circuit case, where I thought we had the better brief on the merits that you participated in, we lost there on a jurisdictional issue. There are no jurisdictional issues this time, that I can tell. And so we think we're going to get a merits decision. We're going to get this decided. And it's a slightly different question in our case, but that is it's bigger than right to try. That's kind of the message I would say. There's a concept that we're litigating here, but also it is the inflexible way the DEA has administered the Controlled Substances Act. In our case, the primary issue is whether or not the fact that something is eligible for maybe RTT or expanded access and has been designated a breakthrough therapy, whether that is a currently accepted medical use with severe restrictions, which is in Schedule 2. And our contention is that it is. DEA in its denial didn't even really disagree with that. It kind of just argued against a straw man. But that's what we're litigating now against in the Ninth
Is this
Circuit.
the appeal of that, or is this a separate
Yeah,
lawsuit?
this is an appeal of that. So we are right now working on our brief. We're looking for amici to join. There are a bunch of interesting issues, and a favorable decision again, I think would have collateral impact outside of this isn't just about right to try. I mean, I think it could have benefits for the cannabis industry. I think it could have benefits for the psychedelic industry, benefits for dying patients. I mean, there are a lot of interests here, and you kind of have to. I think this is kind of one of the concluding thoughts I would put out, which is, I think one of the reasons that I, to the extent I am successful, one of the reasons I am successful is I like to think of these issues as existing in a much bigger space in the controlled substance. Like there are a lot of different moving parts, and I get frustrated a lot with a lot of the people who are sort of worked up about 280E and not seeing that in part of the bigger picture in terms of, rather than sort of attacking 280E directly, maybe if we start taking apart aspects of the system, the whole thing will crumble. And yes, your 280E problem will get solved and a lot of other problems will get solved. I don't see the cannabis industry thinking like that. I don't know why. I know that that's the way pharma thinks and a lot of other sort of well-organized lobbies. And I think thinking bigger picture, seeing how the law interacts, putting pressure on one side of the map, getting you results on the other side of the map. And advocating for patients is good publicity and it's just the right thing to do. And so I would love to see the cannabis industry actively try to get behind more things that aren't just that kind of help help the whole ecosystem out as opposed to something that's about just the bottom line. Because ultimately I think it would help the bottom line. That's the thing. I'm not urging companies or advocacy groups or anyone to do anything that's not in their best interest. I just, I think following the lead of groups like pharma and seeing what they do, I actually don't think very poorly of the pharma lobby in terms of the way they execute. Like they're a well-oiled machine and they do a hell of a job. Like the people there should be proud of how they get to advance the interest of their members. I don't agree with the things they do, but I sure as hell respect the way they are able to get results for their people. And I think that the cannabis industry should demand no less of their people as well. We should be expecting the results.
Yeah, I agree. And yeah, they do need to consider more the big picture. There's so much infighting, so much philosophical infighting, and a lot of it's kind of short-sighted, just kind of thinking about this immediate problem that I want to solve for myself
Yeah.
without, thinking about the bigger picture. And then again, bringing in attorneys with the skill like that you have. It's kind of like the most successful cannabis, and I'm sure this will be the case for psychedelics companies, are run by successful executives who had long careers in regular business. So kind of like you're saying, we got to follow, this is how it's done with pharma. We've got to play that game and play it intelligently, and then beat them
Well,
at their own game.
I should clarify myself because I don't support everything pharma does, and I
Oh,
don't
I know. It just,
well I don't hope cannabis becomes big pharma, but I think we're on the same page here of just in terms of execution, in terms of pharma. A lot of time, all those companies get on the same page on on existential issues, they're always on the same page, right? Like, except sometimes you have the brands against the generics on like a lot of issues because they're, they aren't actually part of the same lobby there. But yeah, I mean that's the thing, right? They get organized, they put aside their differences and so on, and and maybe maybe I'm just not privy to those discussions. But the final point I would make also is like be willing to take on authority when they, be willing to draw some boundaries, right? I mean, if you never draw any boundaries, you're just going to get walked all over. And you know, I I find it unsurprising that safe didn't pass because I don't see the cannabis industry doing anything to I don't see them doing anything to make anyone in Washington fear them. And this is again, not to keep going back to pharma, but do you think this would ever happen to pharma? No way.
No, 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 no. Well, they need to be more organized, and selective in who's representing them, and there needs to be money paid,
Well,
donated
and
for
let
this
me,
to happen too.
yeah, and let me leave. This will be the final thing I say. Like in terms of like, let me leave a suggestion, which is what like I messaging wise, I'm kind of like where why is nobody talking about cannabis and the opioid epidemic? Why is this not the frontline message for cannabis? Why is this, I think messaging wise, like there's no credibility in Washington on the opioid epidemic. There's no credibility at the agencies. They completely botched the whole thing. And the brief you wrote that I've read multiple times, um, at minimum makes a case that cannabis is a promising adjunct to opioids. Like I think there's research in that brief which talks about use of cannabis while using opioids allows a person to use less of the opioid. So we're not talking about substitution here. We're not talking about withdrawal. We're just talking about, a little bit of cannabis goes a long way to reduce the amount of opioids. And like, why is this not the message of the cannabis industry? Like, I mean, look, I'm not trying to get you to answer my questions, but it frustrates me because it's like, you wrote a great brief and makes really persuasive points. And I don't know why those aren't the same points where we're not like pressing, because people do care about the opioid epidemics. I'm not sure people give half a crap about the tax issues of cannabis companies. So that's what that's where I'm gonna leave my sort of podium speech at.
Yeah, no, I mean, I agree with you. It ought to be. I mean, that's absolutely right. I like that a little bit of cannabis goes a long way because if nothing else, if you're able to take fewer opioids and then quit taking them sooner, um, I mean, I just recovered from a surgery and I wasn't given any pain medicine because they don't give that out anymore. But I did okay. Um,
Yeah,
so trying something that really I hadn't really done in the past, but it was helpful. So where is your current right to try litigation pending, and what is your deadline for amicus briefs, and what types of folks would you like to be contributing to this?
yeah. I mean, we're in the Ninth Circuit now. The name of the case is Ames versus DEA. It's the same name as well, it's almost the same name as our first case that was in the Ninth Circuit. Our brief is due in February. The amicus briefs are due a week after it, so I think it's mid-February, around February 14th. Um, we are, if you're interested in writing an amicus brief, you can just reach out to me. We're interested in all sorts of issues, ranging from palliative care to, states that are implementing programs to improve research and expanded access for psychedelics. And just, I think what I was talking about today, which is, how the Controlled Substances Act is administered, which, by the way, is the central reason that marijuana is in Schedule 1 and methamphetamine is in Schedule 2. You make currently accepted medical use the sole arbiter of whether something is in Schedule 1 or Schedules 2 through 5. You end up with this bizarre classification of methamphetamine, which think everyone would agree has one of the highest potentials for abuse in I mean, just all drugs. Fentanyl is in Schedule 2 because fentanyl is used in a hospital, and marijuana is Schedule 1. It is harder to research fent marijuana than it is to research methamphetamine, and that's because of this rigid application of the Controlled Substances Act. There are a lot of other issues that stem from that, but everyone, my view is the cannabis industry should be interested. Certainly, the drug policy groups should be interested. Um, again, if you take a holistic view of all of this, the only way that change is going to happen, whether it's safe banking or decrim or, is you have to start attacking the system. Because for 50 years, there's been this very well-oiled, like this has been built up over time, and it will never change unless people in this industry start changing it, whether it's through the courts or whatnot. I mean, I think the way to get safe banking passed is to start putting pressure in the courts and start sort of making a sharper message about opiates and everything, and being a little bit more confrontational about what's going on, because so I think that those are the people who should be interested, the people who are wanting a change in drug policy, whether it's cannabis or psychedelics, and want to, we're not, in this case, and generally, we're not asking to open up the floodgates, right? We're just asking for the most modest rescheduling of psilocybin from Schedule 1 to 2, so that limited access programs like Right to Try or expanded access can go forward. But the point being, the legal issues underlying what would be required to get to that result are far bigger than the case itself, and that's why people should be interested in it.
Yeah, and the theme that's kind of emerged as we've been talking is, and the frustration about the cannabis industry having so many different voices, so many different issues, is we do need to unite. We need to have a unified voice focused on some of these larger issues and attack the system as a unified voice, as you mentioned. And I hope that this podcast and your work serves as a call to arms. And for folks to learn more about it, you and Shane write an amazing blog, right?
Yes,
Tell listeners how they can find that and read that, and what
sure.
kind of stuff you talk about.
I write along with Shane at ondrugs.substack.com. It's mostly free. We do release some subscriber content. It's not expensive to subscribe, but you can get the lion's share of what we do as a free subscriber. And we write differently. I like that. Like Shane focuses a little bit more on cannabis. I focus a little bit more on psychedelics. I write a little bit longer. Shane writes a little bit shorter. But in every case, what we both do is we talk about drugs. That's it. And we do deep dives, and we talk about what people are saying sometimes, whether it's correct or not. We'll point you to the law. We'll tell you what the law says. And we sprinkle in our opinions there. I don't think it's a unbiased view of things, but yeah, it's online. We would enjoy having additional subscribers. It's we conceived of the newsletter largely because we were working on these cases, and we had so many more ideas about drugs than we could ever pack into cases. And we were just like, you know what, like we're just going to publish it ourselves. So that's what we do.
Well, it's fantastic. And how can folks get in touch with you personally?
So my email, you could Google my name and hopefully it would bring up my firm bio, and my email is mzorn@gettercoleman.com. And I think that's probably the best way to reach me, is to send me an email. And if I don't get back to you, or if I respond and then it goes dry, is to pester me a little bit. Sometimes I just I go on vacation and then get COVID for 10 days and lose track of everything.
I'm glad you made it back.
Yeah. Glad
And
to, glad to be back in the States.
yeah, I want to thank you so much. This has been phenomenal. And I feel like it's been like Joe Rogan interviewing Elon Musk or something. You're so smart. I'm just trying to keep up. And thank you so much for everything that you're doing on behalf of patients and on behalf of the industry, but most importantly, patients and researchers. And we all thank you.
All right. See
All
you
right.
soon.
Thank you.